All right. Good morning, everyone, and welcome to the First District Court of Appeals. We have one case up for argument today. That is Ship versus Norton Outdoor Advertising, case number C210150. And will the parties please state their appearances?
I'll start, Your Honor. This is John Phillips on behalf of the appellant, Jerry Ship et al.
Thank you. Good morning.
Good morning.
And Your Honor, this is Mike Galasso on behalf of Applee Norton Outdoor Advertising Incorporated.
Thank you. Good morning. Mr. Phillips, would you like to reserve any time for rebuttal?
Yes, Your Honor. I'd like to reserve 3 minutes.
Okay, I will keep your time. I'll let you know when you have about 1 minute left.
Okay, I will also set a timer, so if you hear something dinging, it is also my timer. Okay.
All right, you can begin whenever you're ready.
Okay. We're here today to talk about certifying a class. And there was an entry that went on from a visiting judge, Judge Sylvia Hendon, who was visiting at the time. And this case has a bit of a tortured procedural history. But to make a long story short, of course, we're looking at Civil Rule 23 in this case. And the judge in our case never got to do a complete analysis of Rule 23 because she felt that we did not meet the 23A requirements. So I'm going to focus primarily on the 23A requirements, if that's okay with the court. And of course, the 23A requirements are numerosity, commonality, typicality, and adequacy. And the first thing that the judge said was, well, gee, your class is not so numerous as to be impractical to join everyone. And that's not exactly the standard. Well, it's specifically not the standard. We have 17 real estate parcels consisting of 23 different homes on this issue, all of which are under an illuminated billboard that changes its message every 8 seconds. Now, counsel claim they're only operating the billboard currently during daylight hours. And I think that's a bit of an exaggeration because it's actually on from 6 a.m. to 10 p.m. So when my alarm clock went off this morning at 6:45, I looked outside and it's pitch black, which means the billboard had been operating for 45 minutes in the dark, belching light down on Ross Avenue. Now, it also operates until 10 o'clock in the evening. Currently, it's getting dark around 6 o'clock, which means it's operating for 4 hours in the evening, belching down on the neighborhood. Now, the neighborhood ends up with this light show every 8 seconds where the color changes in the neighborhood. There's this wake up every 8 seconds from a different color. And we've got video that and our expert has come out and analyzed it. But the point is, sticking with the numerosity issue, you don't leave your common sense out on the curb when you go into court. We know that there's, on average, more than 2 people per household in the United States. Now, in this case, we got 23 households. There's going to be at least 46 people. We conservatively said 2 per household, just to show that we got more than 40 people in our class. Yes,
But isn't that speculation, though? Yeah, I mean, you're speculating that there's more than 2, and I believe one of the affidavits that you filed, there's only 1 person in that particular residence.
That's right. That's why we used an average of 2, because like the Whitehead property, is a single mother whose her husband is deceased, but she's raising two small children. She's got three. Jerry Shipp and his wife are two. We used an average of two because, like I say, you don't leave your common sense on the curb. We'll be well over 40 when we get to that point of actually counting the class. Now, one of the things that just came out actually in December of 2021 was the Mahoning County CACH LLC versus Young case. It was out of the 7th district. And one of the things that they said is the number of class members with a valid claim is the issue to be determined after the class certification. While the non-movement arguments may, if successful, bar certain class members from obtaining relief, that does not remove those individuals from consideration as potential members of the putative class. And they cite a federal rules decision, Coleman versus District of Columbia. Of course, our Rule 23 is based on the federal rule of class certification. So considering how many members of the class there are at this stage, according to the federal rules and according to our own appellate decisions as most recently as December of 2021, that's not where we should be. Do we have a valid class? And of course, the answer is yes, we do have a valid class. We have a group of people. Now understand, this billboard has been cited as illegally placed. Okay, this is not like we're just saying we don't like this billboard. This is a billboard.
This is in litigation right now, right?
It is in multiple litigation, yes. Now there's an argument by opposing counsel that my clients opposed moving the billboard. And I will say, I'd like to see that in the record, because when they applied to move the billboard across the interstate and I guess a little bit north, we did not oppose it. We didn't even, my clients nor I did not even go to the zoning hearing. And I believe if you push on Mr. Galasso to be a little more candid, there were logistical problems with moving that billboard. There were not opposition problems with moving that billboard. Okay. And
But this information, you said, you're saying, first of all, you disagree, and second of all, it's not in the record. That's your argument.
correct.
Okay.
Well, I mean, his argument's in the record, okay, that we opposed it, but there's no evidence in the record. My argument's in the record that we didn't even show up for the hearing. We did not oppose this. In fact, moving this billboard would go light years towards resolving this entire case. Our primary objective here is injunctive relief. Okay, we want this, my clients want this billboard gone. Okay, we are not about money. Now, I don't know where the miscommunication occurred, but one of the attacks we had on our 4 elements was adequacy, claiming that the only reason this case isn't resolving is because of my demand for legal fees. I will tell you that is not the case. I don't know where that miscommunication came from. It came out of what I thought was an evidence rule 408 situation, as well as Ohio's mediation statute, which we're talking about different ideas on how to resolve this case. One of the ideas was move the billboard, and that's the one I thought we were pursuing. The $150,000 number, I have no idea where that came from. Now, what?
Mr. Phillips, I'm sorry to
Sure.
interrupt, but can you get back to the numerosity
I'm sorry, yes.
argument? Because it's what I understand your argument to be is that you're above the 40 person threshold because we can guesstimate that there's 2 people per residence,
Okay,
right? That, I mean, is that basically your numerosity argument?
That is my numerosity argument, but I don't necessarily have to have 40. I mean, there are cases out there where there have been classes certified with as few as 14 people. So I've got 17 parcels, but
Why were those cases, why did they certify as few as 14 people? And how is your case similar to those?
because they met all the elements just like we do. Okay, they had numerosity, they had commonality, they had typicality, and they had adequacy. I mean, numerosity here with 17 parcels, you know there's going to be more than one person per household on average. These are not vacant properties. Okay, so we know there's at least 17 to start out with. You know that according to government statistics, there's going to be more than 2 people per household. We're trying to be conservative and saying, even if we just use 2 people per household, we're over 40. We got 46. In addition, we have 2 multi-unit apartment buildings, which are not owner occupied, which gives us 2 more owners. That takes us up to 48. And we lay that out in our brief.
Mr. Phillips, Mr. Phillips,
yes.
Let me ask you a question. It appears the trial court, among other things, sort of seized on the numerosity argument. Let me ask this. If you have nuisance claims, wouldn't those claims go to the 17 properties versus the number of people living in those properties? And I'm just asking, for instance, I know there's an apartment building or a 2-family, and it seems the claim would go to the owner of that 2-family within that 500 feet radius. Do you understand my question? Whether it goes to the properties or whether it goes to the individuals living in those properties?
I believe I understand your question, Judge Winkler. The argument goes to both because the property owner is going to have his property value impacted. On the other hand, the resident is going to have his lifestyle impacted. If we
Mr.
think
Phillips, sorry to interrupt, but you have about a minute if you want to reserve 3.
Okay. And again, I'll answer any question, but the people living there are impacted. If we think of this as odors instead of light, you can easily draw the conclusion that, well, wait a minute, the people living there are the ones who have to deal with the stink. In this case, it's the people living there that have to deal with the fact that they can't enjoy that which they are renting or that which they are occupying. They can't go outside and enjoy a fire pit because the light is always, sort of blowing up in their face every 8 seconds when it's dark. I don't know how much time I have left, but I will. Okay, my timer says I am out of time. I will reserve my 3 minutes.
Thank you, Mr. Phillips. Mr. Galasso.
Thank you, Your Honor. Mike Galasso on behalf of Norton Outdoor Advertising. Mr. Gay has ceded his time to me, and I'm also tracking my time. I'll try. I don't think I need to use the whole 15 minutes. This case is about whether class certification is warranted for the particular case. It's not about whether Mr. and Mrs. Shipp have a claim, and clearly they've got a claim and they're making that claim, and that claim will be litigated. The question is whether it's appropriate for aggregate or class litigation. So I just want to talk about the factual history that led us up to this. There's been a sign at this location that Norton Outdoor has operated for over 25 years. And when ODOT did some work, the sign was relocated. And at that time, Norton Outdoor submitted applications to the Village of St. Bernard and to ODOT to get permits to change it from a static sign to a digital sign. And at that time, the code still says for Norton Outdoor, it says that expressway advertising is governed by the rules governing interstate highways. And so there's 2 sets of permits that are required here. And the first is that you get your local permit from St. Bernard, which they did. And then you go to ODOT and you get state permits, and they did that as well. Once the sign went up, the Shipps complained, and the Village took the position that it made a mistake in issuing the permit and that it believed that digital signs were prohibited if they were for billboards. They were only permitted for on-premise signs. And that's the subject of a second BZA case. And, if that case goes to final judgment and Norton Outdoor loses that case, it would moot the relief sought in this case, because that would mean that the sign doesn't comply with the zoning code. But that BZA case, basically, there were two issues that came out of that. And one is that the zoning inspector said, hey, the light from the sign is too bright. And the second one is we don't allow digital signs if they're billboards. And so the magistrate issued a decision and said that the sign wasn't too bright. There was no evidence to support that the sign didn't meet the illumination requirements, but then held that the code did prohibit billboards that are digital. Now, that exact legal issue is at the United States Supreme Court right now from a case out of the Fifth Circuit Court of Appeals involving the city of Austin. There's also a Sixth Circuit case. Well, there's two. There's one out of Tennessee called Thomas versus Bright, and there's one out of Kentucky called Lion's Den Management. And those cases held that you couldn't put up digital billboard bans. And so that's kind of what's at issue in that other case. But in any event, the south-facing sign at the Ross Avenue location can be seen from the ship's yard, and that's not disputed. But what is disputed is whether the light from that sign constitutes a nuisance to them, and they're free to make that claim. We've got an expert, they've got an expert. Our expert says that the ambient lighting that is there from I-75 is much brighter than the sign. The sign is actually less bright than it was before, and that the foliage and the angle and the distance from the sign to the ship's property does not allow the light to intrude on the residents, or nor is it objectively unreasonable. Now, that can be litigated and that can be disputed, but what can't be disputed is the fact that outdoor advertising is not a nuisance per se. And that's what the ship's claim is for class certification here. And basically what you have to determine is whether the light constitutes an unreasonable intrusion as to each specific property. And for example, I pointed out at one point in this case that Lisa Whitehead was not joining as a plaintiff, and her property is immediately adjacent to the sign. And so I don't know if it was Mr. Phillips or someone else said, well, that's because she can't really see the light from the sign because she's so close to it, which just goes to the point that every single class member would have to have a separate liability determination. And so that's really the whole point of my argument in this case is certainly the ships are free to pursue their claims, but whether they should pursue those as a class is what's at issue.
Mr. Galasso, if you were to take what you just said and expand it out, it seems like what you're saying is that there could never be a situation where a nuisance claim could be a class action.
And so, Your Honor, I'll address that because that's what the ships have alleged in their brief as well. And that's not necessarily the case. So if there's commonality, if you could determine from common evidence a liability determination. So for instance, one of the things that the appellants provide is a hog farm case or a smell case. And, you know, you could use common evidence to say everybody within a specific geographic radius of a hog farm would have that smell. Or there's another case that involved radioactive waste. And, you know, everybody that had contamination on their property would have a claim. But what you can't do is expand that to light where the characteristics of each property are different. And so
isn't that the same with the hog farm? I mean, the distance to the hog farm and the way the wind blows and everything is different per property.
So Your Honor, but that could be done by common proof because it would be a matter of degree. Everybody that could smell the hog farm would have some type of claim, and then their damages would be based on, you know, how strong that was or how noxious that was. But there wouldn't be foliage, ambient lighting, different angles and things that would change that analysis. And so what I'm saying is that there's just not common evidence. And if you look at what the trial court did, is the court just basically said that there's no commonality, no typicality, and then they also said no adequacy. So they hit 3 of the elements. They didn't go through all 7, but the court could have found that all 3 of those elements are present and still not certified a class, because it's within the trial court's discretion to manage its own docket and determine what inherently is best for the trial court to manage that position. And that's why the standard of review is abuse of discretion. And it's not enough that the Court of Appeals might have decided the case differently. And that's particularly pronounced where there's been a denial of class cert. And where that happens, it's an even heightened burden to try to reverse that trial court determination based upon the deference that's afforded to the trial court. So one of the issues that Mr. Phillips pointed out was this, this Sophie case or Sophie case and the attorney fee issue. What happened here is that Norton Outdoor put in an application to convert the sign that can be seen from the ship's residence, not the one that can't be seen, but the one that can be seen, to a static sign and move the digital one down the road. There was a letter of support from the village's legal department that would support, a variance request for that. But because the ships were going to oppose that, the variance request was withdrawn and the hearing never went forward. And the only place that I can say that that's in the record in this case is if the court were to look at the BZA case, because it is in the record from the BZA case, and I think the court can take judicial notice of that. But it's really not an issue. I think that's become a distraction, this attorney fee issue. And Mr. Gay cited in his brief a case that's from the Ohio Supreme Court from 2006 called Davis. And it's a public employee retirement systems case. And the court basically said there's no, quote, need for class cert. And the need issue was if the plaintiff won in the case, OPERS was going to apply that uniformly to all members of the retirement system such that there was no need to certify a class. And the same thing is true here. If the ships are successful in obtaining the primary relief that Mr. Phillips seeks in the form of an injunction, then there is no need for a class. And if the BZA case goes against Norton Outdoor, then there is no need for a class. But that goes to the court's inherent discretion to manage its own docket and the factors of Rule 23. So it was incumbent on the ships to prove not 1 or 2, but all 7 of the requirements for class certification, and missing any single one of them would be grounds for denial alone. But even having them all, it's still a discretionary determination by the court. And so I also, aside from the attorney fee issue, I don't think we should get hung up on, I can find a case where, and I cited these in the brief, I can find a case where 220 wasn't enough, or 100 wasn't enough, or 330 wasn't enough. And then Mr. Phillips finds a case and says, oh, well, 40 is enough, or 50 is enough. And I don't want to get hung up on the pure number for numerosity, because the test is whether joinder is impracticable. And so the plaintiff's own evidence in this case shows that it's not impracticable, because they can all be identified from the public records that are cited in the plaintiff's motion for class certification. So joinder is simply not impracticable, and that's what the test is in this case. And then finally, I just wanted to note one other thing, and that is on the nuisance claim. It gets confusing, right? Because there's public nuisances and there's private nuisances, and there's absolute nuisances and there are qualified nuisances. And then, the term absolute and nuisance per se are then used interchangeably. So it gets really confusing. But this is not a public nuisance case, so we can strike that. And it's not, so that leaves it as a private nuisance. And it's not an absolute or a nuisance per se case. And I cited a case from the 2nd District. I cited a case from the 8th.
He pled that. That was pled, right?
I'm sorry, Your Honor?
Absolute nuisance was pled in the complaint.
Yes, it was pled in the complaint. But
Okay.
but Ohio law does not provide that billboard advertising can be a nuisance per se. And so what I'm saying is that if a billboard is a nuisance to a particular property, that's possible. But you can't just say that it's a nuisance per se because it's statutorily permitted and it's permitted by common law. It's a lawful use of
Well,
property.
isn't that
Now,
the question in this case is whether it is statutorily permitted?
No, Your Honor, because whether it's permitted statutorily or not, it doesn't matter with respect to a nuisance. So the plaintiffs would have to show that a person of ordinary sensibilities would have suffered such a severe invasion of their privacy rights as to constitute a nuisance. And so that has an objective prong and it has a subjective prong. And the subjective prong is that in addition to an ordinary person being offended or having that intrusion, they must also indeed experience that injury subjectively themselves in order to have standing to assert a claim.
They
And
have
so-
they have to experience some sort of injury, right?
Yes, Your Honor.
So of course, otherwise they can't get damages.
Correct. But
But
that
the question's how do you prove a nuisance?
Agree. And so, and if you look at what's in the trial court record here, you'll see that there were competing expert reports. The plaintiffs withdrew their motion for injunctive relief. In their brief, they indicate that they elected to do that to pursue class certification. I'm not sure what one has to do with the other, but that is something that they are free to pursue those claims. The question is whether they should pursue those claims on an aggregate basis on behalf of other people. And so the nuisance case that I cited from Kentucky is essentially the same. There's not any difference between Kentucky and Ohio law on that point. And both states follow the restatement of torts, and both states are going to require both an objective and subjective inquiry. And that just can't be done on a class-wide basis in this particular case. And Your Honor, I think that that wraps up my time. Thank you.
All right, thank you. Mr. Phillips, rebuttal?
Okay, I'm unmuted now. Several things. I made some very quick notes here that I'd like to address, hopefully in 3 minutes. First is the zoning law itself. We agree you can have digital billboards in the village of St. Bernard. That is not the issue here. When you look at the village of St. Bernard statute, it specifically says multiple messages or variable message outdoor advertising signs are not permitted. It's the every 8 seconds. It's like they just don't get it. If they were to turn this sign on and have one message so that it's illuminating just the neighborhood constantly with a continuous single glow, again, I don't know that we'd have a claim. It's that the neighborhood changes color every 8 seconds. Okay, the whiteheads are closest to this billboard. It's like I had a flashlight behind me. Okay, it's probably not in my eyes. If it's in front of me, now it's really bad. The ships are in front of the flashlight. The whiteheads are behind it. It doesn't mean it doesn't illuminate their yard, and we've got evidence to prove that. Yes, they have damages. They put in their affidavit to state that. The BZA case. The BZA case had nothing to do with moving this billboard. Zero. It had only to do with whether or not this billboard could remain at this location and continue to operate as it is. We are an amicus curiae in that BZA case, and the magistrate did find, no, you know what? This is an illegal billboard. Now, we limited our class to 500 feet. Why? Because the Village of St. Bernard's ordinance specifically says no billboards within 500 feet of a residentially zoned area. Thus,
Mr. Phillips,
Yes,
Mr. Phillips, I'm going to interrupt you for just a second. So Mr. Galasso said, brought up the need for a class issue. If the ships on their own took on this case and won, and the variable billboard was no longer permitted, wouldn't that solve the problem for everybody else that lives there?
it would. That's one of the things we're asking this court. Well, it could, it should. Now, whether or not that would occur or not is we still have our backup nuisance claim, which is that this billboard is still an unreasonable interference on a residential neighborhood because it is still within 500 feet of a residential zone.
But
So
wouldn't that obviate the need for a class? That's what I'm
No.
getting at.
no, because much like the hog farm case, the hog farm was zoned appropriately, but it was imposing a nuisance on the neighborhood. So much like this billboard could still, even if they won their BZA case, and somebody says, well, the Village of St. Bernard's ordinance is not reasonable, it's blah, blah, blah. Okay, that doesn't mean the billboard's not a nuisance for the people that live there. So there's a nuisance doesn't have to be a zoning violation.
That's
But
not what
it's
I'm
not-
asking. I think
Okay.
we're on two separate pages here.
I
What I'm
apologize.
saying is if in your case that you filed, if a class was not certified and the ships won, and it was determined to be a nuisance and the billboard had to go away, wouldn't that take care of the entire street?
Obviously, yes, it would. I mean, I think your question, I don't want to say it's rhetorical, but yes, if the billboard goes away, everybody on the street is happy. Yes, so I could see that being the case, but I've got 17 different properties all right now angry at this billboard, all that would like to litigate. Some of them have approached me and I have told them, let's hold off. Let's see how the class works out, because I think you're better off doing this once as opposed to doing it 46 times.
And Mr.
That's-
Phillips, and you
Yes.
are way past your time, but I know you were
I
answering Judge
apologize.
Box. No, it's not. You were answering Judge Box questions, but I actually have another question for you, and
Yes.
that goes to the numerosity. Why is jointer impracticable in this case? If you can identify every single property and every person in the property.
The residents, this is a relatively low income neighborhood. They can't afford to bring their own lawsuits. Could I join them all? I mean, by going up and down the street, knocking on doors and trying to join them. It doesn't seem practical. It seems like it's a better case for injunctive relief. I mean, our goal is to get rid of the billboard. We think it's a better case for a class than trying to join 46, 48 people, whatever it turns out to be, or 55, until we get our class certification, we have not done the numbers, but it makes it much more difficult.
Thank you. Thank you both for your arguments this morning. We're going to take the case under submission and issue a timely decision.
Very good.
I believe that concludes our session today. Have a good rest of your day.
Thank you.